Good afternoon, everyone. My name is Surya Dzuhurillahi, and I'm a student from University of Pancasila, and I'm majored in law, and my student number is 3021210208, and I'm from EOP Class C, and today I'm gonna do a presentation about general protection of civilians under the power of the enemy. Protection of civilians under the power of the enemy. The rules and fundamentals principles of international humanitarian law governing the protection of civilians who find themselves under the authority of warring parties wherever in their own national territory or in occupied territory are set forth in Articles 27 to 34 of the Fourth Geneva Convention and Articles 72 to 79 of Additional Protocol 1. Protective scope of the Fourth Geneva Convention. The Fourth Geneva Convention doesn't mandate states involved in conflicts to protect their own citizens, citizens of neutral countries on their territory, or citizens of allied nations. However, maintaining normal diplomatic relations with the concerned countries is required. Individuals ineligible for prisoners of war status concerned countries is required. In- Individuals ineligible for prisoners of war status remain protected by international humanitarian law. Additional Protocol 1 stipulates that individuals affected by international armed conflicts but not granted prisoner of war status must be treated humanely and have fundamental rights, including access to justice. There's there's a consensus that individuals under the control of detention of warring states should be safeguarded by international human rights law, ensuring no one under the authority of parties involved in armed conflict is without protection from international humanitarian law. Those engaged in conflict are responsible for the treatment provided by their agents to those under their authority, regardless of individuals' responsibility. Individuals under the control of the enemy of conflict cannot even voluntarily waive their guarded rights under international humanitarian law. The next one is treatment with humanity and non-discrimination. Individuals under the authority of warring parties have the right to humane treatment at all times. They possess rights to respect for their persons, honor family rights, belief, religious practice, and their freedom to observe their customs and traditions. They should be also shielded from violence, insults, and public curiosity. These actions are prohibited wherever committed by civilians or military personnel and apply universally consistently. Fi- consistently. Like first one, violence against life and health, particularly murder, physical punishment, mental or physical torture, and mutilation. The second one, pillaging and inhuman treatment of personality dignity, especially action that humiliate, degrade, as well as any form of sexual or abuse. The third one is physical or moral coercion, including reprisal, corporal punishment, collective punishment, and attempts of intimidation or terrorism. Differentiation in treatment may sometimes be justified based on health, age, or gender. However, in all other circumstances, discrimination based on race, skin, color, gender, language, religion, or belief or political or other opinion, national or social background, wealth, birth, or any other status or similar criteria is strictly prohibited. B. Rights to communicate. Communication with protecting powers of ICRC, civilians in area controlled by the enemy during conflict have the rights to communicate individually or collectively with protecting powers. The ICRC, national societies, or other assisting organizations, such communication can involve feedback, complaints, protests, requests for aid, or any appropriate form given the circumstance. The warring parties must facilitate visits by delegates of protecting powers and the ICRC, and as much as possible, representatives of other aid organizations. The next one is maintaining and restoring family links. Every Everyone in area controlled by the warring parties must be allowed to exchange purely personal messages with their personal member wherever they may be and receive news from them. If necessary, with the help of central tracing agency and national societies, the warring party should also facilitate search by separated family members due to war, enabling them to re-establish contact and if possible reunite. The foreign parties should particularly encourage the work of organizations engaged in this task, provided these organizations are accepted to them and comply with their security regulation. C. The rights to take security measures. While international humanitarian law mandates war parties to respect and protect civilians in areas under their control, it also explicitly recognized their rights to take control and security measures concerning protected persons as required by the situation resulting from war. Although international humanitarian law doesn't provide an exhaustive list of permitted security measures, it established that in any case, the most severe action allowed are designating residence and internment. D. Special protection for certain categories of people. A. Women. During times of war, women often find themselves solely responsible for caring for children and dependents, facing extremely challenging conditions. Additionally, they are highly vulnerable to the risk of violence and sexual abuse by armed combatants or organized criminal groups. Hence, in international humanitarian law emphasizes that women should be especially protected against attacks on their honor, particularly against rape, forced prostitution, or any form of indecent assault. B. Children. Obligation to provide protection and care. Children are among most vulnerable during armed conflicts. Orphans or children are left alone often resort to seeking safety, food, and shelter with armed or organized criminal groups, making them victims of forced recruitment, slavery, and sexual violence. Hence, warring parties must ensure that children under 15 years old are left seek necessary resource alone and that all children under 12 years old have identification or similar means of identification. Second one is recruitment. Children recruited into armed force or group face significant dangers and violence in war zone. As combatants or civilians directly involved in hostilities, they can legitimately become military targets. Therefore, warring parties should take all possible measures to prevent children under 15 from direct participation in hostilities and particularly refrain from recruiting them into armed force. When recruiting those aged 15 to 18 below, priority should be given to older ones. The third one is evacuation. During conflicts, warring parties should facilitate accommodation for unoccup- unoccupied children under 15 in neutral countries. However, they shouldn't evacuate non-citizen children to foreign countries unless temporarily necessary for their health, medical treatment, or safety. Evacuation in occupied areas must align with Article 49 of the Fourth Geneva Convention. C. Journalists and war correspondents. Journalists working in conflict zones unavoidably face incidental losses due to the nature of their work. Their biggest risks stem from their specific roles and being detained on charge of espionage or belief targeted by opposing forces, group, or individual opposing independent media coverage from the conflict area. However, the reality is that journalists face danger in conflict areas are not because of a lack of legal protection, but to lack of respect for the protection granted to them under international humanitarian law. IHL doesn't grant journalists special access to conflict zones or communities affected by conflict. In principle, it gives them the same rights or imposes the same restriction as ordinary civilians. Thus, it entirely depends on the warring parties to decide whether they want to grant special privilege to journalists or within the boundaries of international humanitarian law whenever they wish to impose stricter limitation on journalists than those applied to the general civilization population. D. Refugees, stateless people, and internally displaced persons. Cross-border refugees, state, stateless persons trapped in armed conflicts often face extremely challenging situations. They are not citizens of territorial state and cannot rely on protection of their home country or their last country of residence. Therefore, it's crucial not to exclude them from international humanitarian law protection or place that place them in less favorable position on formalistic citizenship criteria that do not reflect their actual situation. The Fourth Geneva Convention specifies that warring parties must not consider individuals solely on enemy nationalities just because de jure they are citizens of enemy party in a conflict. Additionally, as refugees fleeing persecution, they cannot de facto rely on protection from their own nation. While internet while internal displacement is a major humanitarian crisis in many armed conflicts, international humanitarian law treaties doesn't specify address that issue. They only afford internally displaced persons at the same protection as civilians, and internal displacement refers to individuals or groups forced or obligated to flee their homes due armed conflict, general violence, human rights violations, or natural human-made disaster, yet cannot cross internationally recognized state borders. That's all from me. I'm sorry if there is any mistake in my presentation, and thank you for listening.